Now back to the show. This is AM 650's The Law Show.
Welcome back to the program. We have the lads from Hobbs Giroday in studio. David Hobbs and Ian Giroday are Vancouver estate litigation lawyers with offices opposite the courthouse downtown. And this edition of the Law Show, we're going to talk about estate planning to avoid successful wills variation or change claims and or to reduce probate fees and taxes. And before we get into strategies, I wanted to just ask you about probate fees, taxes on wills. It costs to die, and so how does that get paid when a person passes along? As I understand it from previous encounters, Ian, anybody the person who died owes money to gets paid first. So I would assume the tax department would get on that list with their wills or probate fees right away. Is that how it works?
Yes, I think the government would challenge the idea that probate fees are a tax per se, but there's no inheritance tax beyond probate fees.
Okay.
Before the probate registry at the Supreme Court will issue the grant of probate or a grant of administration where there's no will, you have to show up with your bank draft or money order or certified check with the calculated probate or administration fee.
Oh, so this is the case, David, whenever anyone dies, the probate process is simply permission from the court to proceed with the will and the dissolution of the estate, correct?
Well, when you're in the probate process with the probate registry, the court system, one of the important documents that must be prepared and filed is a statement of assets and liabilities. Mm-hmm. It shows the net value of the estate, but the probate fee is on the gross value of the estate. So to take a simple example, if the estate was $1 million, then once you've filed everything and done all the things that you need to do to get your grant of probate, the probate registry will show you that grant. It'll be on the other side of the counter, mm-hmm. and they'll say, here it is, but now you will pay us the probate fee. And if it was $1 million estate, you'd give them a check for $14,000.
Oh, I see. So it's a flat fixed rate, and that's how it goes.
1.4% of the gross value of the estate.
Okay.
So in a $2-3 million estate, which is not atypical for some people that have real estate and so on, if you gift everything away before or create joint ownership such that nothing passes under the estate, you're trying to avoid $20,000, $30,000, $40,000 of probate fee. That would be what the exercise is about.
That your beneficiaries could actually enjoy and have a lot more fun with than giving it to the government.
Correct.
All right. Now, Ian, you mentioned just before we went to the break, you brought up the word trusts, and David was talking about gifts. You both were in our first segment. Just before we went to break, you started talking about trusts. First and foremost, what's the difference between a trust and a gift?
Well, a gift is an outright granting of property, in the larger sense of real property or an asset,
right,
to the person that you're giving it to.
In exchange for nothing, right?
Right.
It's a gift.
Right.
Okay.
No consideration is what we say. If there's consideration, then you're talking about a contract and so forth.
All right.
A trust, now assuming that you're giving an asset to someone to hold in trust, it means that you're giving them the asset to divest it or pass it on to the beneficiaries of the trust, and frankly, he or she could be, the recipient could be one of the beneficiaries mm-hmm. of the trust, but there could be others, or to do something with that asset, like sell it and divide the proceeds amongst the beneficiaries.
Okay, now that's the example we were using, David, before we went to break. We were talking about mom passing the house along to the oldest son, basically on a verbal exchange that says, I want you to be in charge of selling this house after I pass along and dividing the spoils equally among your brothers and sisters.
Right.
That's the arrangement that mom gives to the oldest boy, and that's the way she wants this handled. Is that oldest son now responsible? Is he a recipient of a gift, or is he now in charge of a trust?
Well, the way you've described the background, it's a trust. He's she's taken legal title to the house. She's transferred it in his name. He's a trustee. He's the legal owner, not the beneficial owner, just the legal. He's the named owner, but as to the value of it, the beneficial interest, that belongs to the people that are supposed to receive the benefit, if
Right.
you will, the beneficiaries.
Right, and he would ultimately be 1/5 of that group. then.
Yeah,
Okay.
he can be part of the group.
Sure.
And so he's a trustee. He holds the legal title and trust for the beneficiaries. In our example, it's 5 children. The asset of the trust is ultimately the sale proceeds.
Of the house, right.
The instructions of the trust are sell the house. That's telling the trustee what to do,
Right.
and ultimately then telling him what to do vis-a-vis distributing the assets. The trust can be anything. The trust could be distribute to 4 of my children, and as to the 5th child, that child is mentally disabled, and I want you to retain their share and invest it for them, and
In another trust.
an ongoing trust,
Right,
and,
right, okay.
and give them the income for their education, care, and benefit from time to time.
Okay.
So it would be a trust that would be very specific and end quickly vis-a-vis 4 of them, but the 5th go on for many years as an operating trust with a trustee and a beneficiary and a set of instructions as to what to do.
So what's the difference between that? Mom says, "Here, Junior, number 1 son, you're now in charge of the disposal of the house, the family home, after I die, and here are my instructions." What's the difference between that and owning a property, owning that house jointly? Mom decides that she wants this plan executed, Ian, but she's not 100% confident that Junior's going to follow her instructions to the letter, so she decides to go into a joint ownership arrangement with that oldest son. Is there an advantage to that?
Well, there's 2 types of joint ownership of real property.
Okay.
You know, if we want to use the house example.
Sure.
There's what you call tenants in common, and that has no right of survivorship. So that when the first of the 2 who dies, that their share would fall into their estate
I see.
unless they've gifted it in some other fashion.
Mm-hmm.
It doesn't go to the surviving owner. There's joint tenancy as the second type of common ownership, and that does have a right of survivorship.
Automatically, when one of the 2 signed onto the document dies, the balance, that person's balance, goes to the other signatory.
The survivor becomes the whole owner.
Got it.
But regardless of whether there's a transfer of 100% of the ownership during lifetime or the creation of a joint tenancy during lifetime, the reality is with the joint tenancy equally as an outright transfer of the 100% ownership during lifetime, it may be impressed by a trust. It may be a gift. It may be impressed by a trust.
Okay.
And there's subtleties and all sorts of issues that legal advice and tax advice help with. I mean, one of the things about homes and principal residences is generally they're tax exempt,
Yes.
right? It's one asset that I don't have to pay a capital gain on.
Mm-hmm.
But if I transfer it to someone, they become the new owner of it. Is it their principal residence? Maybe not anymore. Now, when they sell it, is there a tax that may have arisen based on the gain between when I transferred it to them and when they sell it? I.e., we may create a capital gain. Just something that has to be thought about in terms of the planning. Another little subtle issue is I can transfer property to someone and I can name them as trustee on the title. So it was in my name, it's now in Fred's name as trustee, and it shows right on the title that he's a trustee.
Right.
Quite often people transfer and they don't mention that it's a trust on the title, so when you read the title, your most obvious notice that it's a trust is missing, which is the word right on the description of who the owner is, Joe Blow, trustee.
Right. Okay.
But people don't do that. They
So-
just go Joe Blow, and so there's no evidence that it's a trust.
So, and then people end up at Hobbs Giroday going, "No, wait just a second. Somebody forgot to write the word trustee on this document, and now I'm hooped. I'm left out of the whole picture, and it's going sideways on me, all because someone didn't write down the word trustee to describe the position of a person in an arrangement," right?
And in the matters we're involved in, usually it's not one thing, it's many things that are either there or not there. It's like a bowl of soup with all sorts of things in it that some go one way, some go the other way, and you're sitting there weighing weighing what direction is this going to end up.
Ian, you look like you want to chip in on this.
Well, I mean, the reality is that more often than not, these ideas that, I'll put it in the joint name with the executor.
Right.
And, it's more likely to be an informal arrangement as it is an actual written trust. I mean, I'm getting a little bit out of my league when I start talking about what the Land Title Office might require when you say you want to create a title which indicates that one of them's a trustee. Like, for example, does the Land Title Office then say, well, please file the trust document that the trust relates to then?
Oh, I see.
And they do.
And they do.
Well, there you go. So David knows more about it than I do. So as often as not, though, it's just, mom saying to the trusted son or daughter, well,
here's what I want you to do.
Yeah, exactly.
Right, okay. So we're talking about joint tenancy. The notion that, again, we're talking strategy here to avoid tax and to make the whole matter of passing on and people enjoying the benefits of my lifetime as I want them to. So we're talking about joint ownership of real property. What about joint ownership of my money, as in bank accounts? How does that play into strategies for, I guess, the hereafter, if you don't mind my using that term? Joint bank accounts, David, where do they come into play in terms of being a smart strategy, estate planning-wise?
Well, it's the principles are similar for personal property versus real property. We've been talking about homes and land and real property. So now let's talk about personal property. Simplistically, you can consider that to be everything else. My stocks, my money, my jewelry, my car, that's the world of personality or personal property.
Okay.
So at a bank, I'll have a bank account in my name. The money is my money. The bank acts as my banker. They hold the money on deposit for me. When I come to the bank and I arrive there and I say, I'm going to put Johnny on, we're going to make this a joint account. I may do it at the opening of the account, or I may do it at some point during the lifetime of the account.
Right.
The bank will give you a form, and the form will have a place that refers to joint account, and then it'll probably have some words that talk about right of survivorship. And those words are the notion of who dies first.
Right.
So if A dies first, B ends up being the owner
in control of that account.
And that's because they enjoy the right of survivorship. That's, if I survive, my right is I become the owner.
Okay.
To try to dissect it a little bit. And when we were talking about gifting, if I make you, Sterling, the joint account holder of my bank account, my gift at the time we do that is the right of survivorship. It's what you now have that you didn't have before. Before it was just mine. Now, if you manage to outlive me, you're going to get the money, and that's the gift I've given to you, that right of survivorship. And so we think in terms of a gift of the right of survivorship when a joint account is created. And if I die, it doesn't fall in my estate. It's not under my will. It's going to go to you because you have the right of survivorship. And all you have to give the bank is a death certificate.
And they release the funds if you want.
Well, they'll put the account in your name.
Wow, just that easy.
Yeah.
So now we talked about the ransacking of the house. Now, does this happen at the bank level too, Ian? When you have these contentious joint accounts and so on, do people get in there and just scoop the loot rather than risking any future challenges from siblings or other parties? Just give me the money, please.
Sure. One of the things you have to look at when someone comes into our office, or we have to look at when someone comes into our office and says, Mom set up joint bank accounts with Johnny, but we're pretty sure that he was meant to distribute the proceeds or the amounts in those bank accounts equally between all of us kids.
Sure, yeah.
One of the things we have to consider is, do we run off to court and seek an injunction to freeze the accounts so that Johnny can't withdraw those funds, put them into some other account, and or dissipate them. Mm-hmm. So yeah, absolutely, we're looking at that.
But sometimes, I mean, I'm talking probably fairly rare cases, but I'm thinking there are some pretty sharp operators, and I use sharp in questionable context, who would, like the day after get the money out and get it offshore. Get it out of the country now. Now what's the rest of the family going to do?
Well, they're on a practical level, forget about the law, lawyers, and anything else. On a practical level, they have a big problem.
Yeah.
I mean, the world is a big place, and maybe the country that they've gone to the money with doesn't even
I'm thinking,
accommodate anybody coming in.
I'm thinking of some tax haven like the Caymans or somewhere else where it's almost impossible to get in there legally with government clout, etc., and retrieve those funds.
No, and that would be a very difficult problem to overcome, depending on which country you went to, et cetera, et cetera. But the expression "possession is 9/10 of the law," which lawyers don't subscribe to. But the reality of it is if you dissipate the money and move it somewhere, you've got to find it. What are the laws of that jurisdiction? Is it still there? Can you do anything about it anyways? And there's lots of corrupt places in the world, we suspect. So,
on the other hand, we'd be looking at things like, well, okay, you were a trustee of those funds. You dissipated them. You're in breach of trust.
Right.
We can sue you in general, for a more general thing than retrieving that specific asset.
So it's a civil thing. Even though there's some sort of criminal behavior, you're still dealing with it as a civil matter, aren't you?
Yes.
Okay.
And if the person...
Is that preferred, by the way? Does it get to keep the wheels turning faster?
Well, I think what we're talking about here is the subtlety that a person might be still in British Columbia, even though the object has been moved somewhere else.
Exactly.
And the court can exercise jurisdiction over that person. So they can order the person to do or not do certain things using injunctive relief. But you always feel much worse off if the object has gone missing.
Yeah, exactly.
Leaving aside all the other possibilities.
We're attributing all sorts of nefarious intentions to probably some pretty decent people in the course of this program. But you people are estate litigation lawyers. You deal with this percentage of the population that somehow or another feels the need to sneak around and do bad things from time to time, and you have to unravel all this stuff.
Yeah, I think you have to understand that if someone's coming into our office and saying we're concerned about the conduct of our sibling.
Yeah.
In that context, that they must have some. They're either on a complete flyer, and we can sniff that out pretty quickly.
Sure. Or
they must have some decent basis for that suspicion. So we're seeing a small percentage of persons. It's not sort of the general population that is being accused of being nefarious. It's really we get a select sampling, so to speak.
I'll just bet you do. Some of these must be pretty interesting characters. David Hobbs and Ian Giroday from Hobbs Giroday are guests on this December 1st edition of The Law Show, and we'll be back with lots more right after this quick timeout.
This is AM 650's The Law Show. There's more of the show still ahead.